Before we begin, a clear note. This episode is based on public court records. Any court or witness-style voice in this production is a synthetic source reading, not a real interview, not archival audio, and not a cloned voice. On the morning after Christmas, firefighters entered a bedroom in Bremerton, Washington. The room had burned, the bed had burned, and on that bed they found Dawn Hacheney. At first, the story seemed simple, in the way accidental tragedies sometimes do. A space heater, wrapping paper, propane canisters from a Christmas gift, a woman who had not been feeling well, a drug in her system that her husband said might explain why she did not get out. But the body held a quieter question. If Dawn died in that fire, why was there no soot where breath should have carried it? Why was there no carbon monoxide in her blood? Why did the evidence suggest not that she failed to escape the fire, but that she never breathed after it began? For years, the official answer was accident. Then a woman came forward. She said she had been having an affair with Dawn's husband, Nicholas Hacheney, a pastor in a large church. And according to court records, she said Nicholas told her something very different. He told her that on Christmas night, after Dawn had taken Benadryl, he lay awake until God told him to take the land. Then, she said, he held a plastic bag over Dawn's head until she stopped breathing and set the fire. This is the story of a death hidden inside an accidental fire file. It is also the story of how a court later drew a hard legal line. A fire can hide a murder, but that does not always mean the murder happened in the course of the fire. The case is State v. Hacheney. The victim is Dawn, and the question at the center is not only what burned, it is what the first investigation could not see. The public appellate record begins with a small domestic detail. On December 25, 1997, Nicholas and Dawn Hacheney attended a Christmas party. They returned home late in the evening. Dawn's mother later reported that Dawn had not been feeling well that day and that she was taking Benadryl. Nicholas Hacheney was one of several pastors at a large church in Bremerton, Washington. That fact matters, but not because a church title proves guilt or innocence. It matters because it shaped the world around the couple. It shaped who trusted whom. It shaped what people thought they were seeing. It shaped how a shocking allegation, when it eventually came, would move through a community built on spiritual language and personal authority. The next morning, December 26, Nicholas left early to meet friends for a hunting trip. Soon after he left, neighbors noticed a fire at the Hacheney home. Firefighters responded. They put out the blaze. The fire had damaged the bedroom. On the bed, they found Dawn's badly burned body. In that same bedroom, they found several propane canisters and an electric space heater. According to the Washington Supreme Court summary, Nicholas gave investigators an explanation that fit the scene. He said he and Dawn had opened Christmas presents late the night before. The propane had been a Christmas gift. Wrapping paper had been left in front of the heater. He said he turned the heater on before he left that morning. He also said Dawn had gotten up during the night to take Benadryl and suggested her sensitivity to the drug might explain why she did not escape. That explanation had the shape of an accident. Heat, paper, fuel, a sleeping woman, and medication. It was plausible enough that the early official path moved in that direction. But fire scenes can be deceptive. Fire destroys. It rearranges a room. It consumes the evidence people expect to see. And when there is a body in the middle of the burn pattern, investigators have to ask two questions at the same time. What started the fire? And was the person alive when the fire started? In Dawn's case, the second question would become the one that changed everything. The autopsy found no soot in Dawn's trachea or lungs. Toxicology testing showed no carbon monoxide or cyanide in her blood. In plain terms, the court records describe evidence suggesting Dawn did not inhale after the fire began. She also had an elevated level of Benadryl in her blood. The autopsy noted pulmonary edema, fluid in the lungs, which can be associated with suffocation, but also with other causes. At the time, the forensic pathologist concluded Dawn had asphyxiated when her larynx reflexively closed as the result of a flash fire. The court record says the conclusion was based in part on the fact that there was no suspicion of foul play at the time. That detail is important. A medical conclusion was not made in a vacuum. It was made in a context. If the context says accident, ambiguous signs can be read in the direction of accident. If the context later changes, those same signs can look different. The original police and insurance investigations concluded that both the fire and Dawn's death were accidental. The Washington Supreme Court later noted that at least one investigator reported being uncomfortable with that conclusion, but uncomfortable is not the same as probable cause. Suspicion is not the same as proof, and for several years the case did not move as a homicide. A woman was dead. A husband went on living. A church community carried on, and the bedroom fire became a closed story. Until 2001. In 2001, Sandra Glass approached investigators. According to the court record, she told them she had been having an affair with Nicholas Hacheney during the summer and fall of 1997. That alone did not prove murder. Affairs can be motive evidence, but they are not a confession. They can explain pressure, secrecy, or divided loyalty, but they do not tell a jury what happened in a bedroom. What changed the case was what Glass said Nicholas had told her.
Court records say Glass reported that a couple of weeks after Dawn's death, Hacheney confessed. She said he told her that on Christmas night he had given Dawn Benadryl, then lain awake until God told him to take the land. She said he told her he held a plastic bag over Dawn's head until she stopped breathing, and then set the fire.
That phrase, "take the land," appears in the appellate opinion as a biblical phrase interpreted by members of the church as an admonition to act. In a normal context, religious language can be metaphorical, motivational, even ordinary inside a faith community. In this context, as Glass described it, the phrase became part of a murder allegation. The state also learned that in the months after Dawn's death, Nicholas had ongoing sexual relationships with at least 3 additional church members. At trial, evidence of those relationships was admitted for limited purposes. Motive, intent, premeditation, or consciousness of guilt. That does not mean the jury was allowed to treat affairs as proof by themselves. It means the court allowed the jury to consider them in a narrow legal way. By September 2001, the Kitsap County prosecutor charged Nicholas Hacheney with first-degree premeditated murder. The state's theory was no longer that Dawn had died because she could not escape a fire. The theory was that she was suffocated before the fire began, and that the fire was set afterward. This is where the case becomes more than a story about a hidden crime. It becomes a story about sequencing. If a person is alive when a fire is set and the fire kills them, the law can treat the fire as part of the killing. If a murder is committed during a listed felony, that felony can become an aggravating factor. In Washington, aggravated first-degree murder can mean life without the possibility of release when the death penalty is not pursued. But what if the murder is already complete before the fire starts? What if the fire is not the means of death, but the attempted cover? At trial, the prosecution pursued first-degree premeditated murder. It also pursued an aggravating circumstance connected to first-degree arson. The state alleged that the murder happened in the course of arson. The defense challenged several parts of the case. It questioned evidence, procedure, and later the use of unavailable witnesses and toxicology reports. But the core factual dispute was stark. Dawn's body had been found in a fire. The state said she did not die in that fire. The state said she was suffocated first. And then it asked the jury to connect that murder to the arson anyway. That request would follow the case all the way to the Washington Supreme Court. Forensic evidence can sound clean when it is summarized after the fact. No soot, no carbon monoxide, no cyanide, elevated Benadryl, pulmonary edema, suffocation, fire. But in a courtroom, Those words do not arrive as a single conclusion. They come through witnesses, reports, objections, and expert interpretation. The Court of Appeals later described how Dr. Emmanuel Laxina, the Kitsap County medical examiner, performed the autopsy. He found no soot in Dawn's trachea or lungs. He found pulmonary edema. He collected blood and lung samples. He requested toxicology after the autopsy results made him suspicious that Dawn might have been dead before the fire consumed the home. The Washington State Patrol Crime Laboratory toxicologist, Eigler Weiss, tested the samples. The court records say the tests revealed no carbon monoxide in Dawn's blood and lungs, and no propane in her lungs, indicating that Dawn did not inhale after the fire began. They also showed an elevated level of Benadryl, but Weiss died unexpectedly before trial. That created a later legal problem. The report existed. Other doctors and a supervisor testified, but the analyst who performed the testing could not be cross-examined. In a true crime story, it is tempting to treat science as the clean voice of certainty. The Hacheney litigation shows something more complicated. Scientific evidence is powerful, but the law also cares about how that evidence enters the courtroom. Who performed the test? Who signed the report? Who can be cross-examined? Did the defense have a fair chance to challenge the chain of conclusions? The trial court admitted Weiss's toxicology report over Hacheney's objections. Doctors testified that Dawn died from suffocation before the fire started, and they relied in part on the report. Years later, Hacheney argued that later United States Supreme Court cases about forensic reports and confrontation rights should change the outcome. The Washington Court of Appeals did not give him relief. It held, in essence, that those later rules could not be applied retroactively in his collateral attack in a way that would undo the conviction. That is a legal conclusion, not a fresh scientific finding. And for this episode, the distinction matters. The court records do not ask us to become forensic pathologists. They ask us to follow what the court said the evidence showed and how the courts treated the legal challenges. Dawn's lack of inhalation evidence was central. The Benadryl level was part of the story. The alleged confession gave investigators a new lens through which to view what had once been called an accident. The trial itself was long. The Washington Supreme Court described it as involving several expert witnesses. The jury heard about the fire. It heard about the autopsy. It heard about the relationships after Dawn's death. It heard the allegation from Sandra Glass. It heard the defense challenge the state's proof. Then the jury was asked a question with two layers. First, did Nicholas Hacheney commit first-degree premeditated murder? Second, if he did, was that murder committed in the course of first-degree arson? On December 26, 2002, 5 years to the day after the fire, the jury answered yes to the first question. It found him guilty of first-degree premeditated murder. It also answered yes to the second. It found the arson aggravating factor. That special verdict changed the punishment. With the aggravator, Hacheney was sentenced to life in prison without the possibility of release. But during deliberations, the jury had asked something revealing. Jury questions can be windows into the real problem in a case. They are not verdicts. They are not arguments. They are moments when 12 people say, in effect, "We need help with the hinge." In Hacheney's trial, the jury sent the court a question about the arson aggravator.
Would arson be an aggravating circumstance if Dawn Hacheney was already dead, but other people were injured by the fire? For instance, the insurance company, Dawn's parents, and Dawn's body.
The court responded that it would not provide further instructions and told the jury to review the instructions already given. Then the jury asked again.
For arson to be an aggravating circumstance, did the fire have to result in the injury to a living person, or only related to the murder, assuming Dawn Hacheney was already dead?
Again, the court did not provide further instructions. Those questions go directly to the legal issue the Supreme Court later resolved. The jury was asking whether the fire could aggravate the murder if Dawn was already dead. They were asking, in ordinary language, whether a cover-up fire could count the same way as a killing fire. The trial instruction told jurors that to establish a killing occurred in the course of another crime, there had to be an intimate connection between the killing and the other crime. The killing and the other crime had to be close in time and distance. But more than coincidence was necessary. A causal connection had to be clearly established. That instruction sounds technical, but its moral shape is understandable. If two crimes happen near each other, they are not automatically one legal event. There has to be a connection that matters. The state's theory, as described by the Supreme Court, was that Dawn was dead before her body was burned by a fire started in the bedroom. The state argued the murder and the arson were intimately connected because the arson was part of the same sequence and helped conceal the killing. The defense argued that the murder could not have occurred in the course of the arson because the murder was complete before the arson began. On direct appeal, the Washington Court of Appeals initially upheld the aggravator. But the Washington Supreme Court took review on two issues: the arson aggravator and the use of videotaped depositions from 3 witnesses who were out of the country at the time of trial. The confrontation issue mattered, but the Supreme Court did not reverse the conviction on that ground. It held that those witnesses were unavailable for confrontation clause purposes. The arson issue was different. The Supreme Court looked back at older Washington cases and explained that to show a killing occurred in the course of a felony, more than close timing and location was required. There had to be a causal connection. The death had to be a probable consequence of the felony. In this case, the court said the murder was not a probable consequence of the arson. It was the other way around. The state's evidence was that the murder happened first and the arson came after.
We conclude that, as a matter of law, Hacheney did not murder his wife in the course of arson.
That sentence did not say he was innocent. It did not erase the first-degree premeditated murder conviction. It did not say the fire was irrelevant. It said the fire could not legally carry that specific aggravating factor. The court affirmed in part, reversed in part, and remanded for resentencing without the aggravator. For Dawn's case, the result is complicated. The conviction stood, but the sentence structure changed. The law acknowledged a difference between a murder committed by fire and a fire set after murder. That difference may sound narrow. In appellate law, narrow can be everything. There is another layer to this case that the court opinions describe only in necessary fragments. The church community. Nicholas was a pastor. Sandra Glass was connected through that religious world. Other women named in the evidence were church members. The phrase, "take the land," had meaning inside that world, and the alleged confession was described not in ordinary criminal language, but in spiritual language. This is where a documentary has to move carefully. A church is not on trial. Faith is not on trial. Religious language is not, by itself, evidence of murder. But authority matters. Trust matters. The role a person occupies can affect what others believe, what they excuse, and how long it takes for a suspicion to become a report. When the state introduced evidence of Hacheney's relationships with several women after Dawn's death, the trial court gave a limiting instruction. Jurors were told they could consider the relationships only for certain purposes: motive, intent, premeditation, or consciousness of guilt. They were not told to convict him because he had affairs. They were told to consider whether the relationships helped answer specific questions about his state of mind. That distinction is not just legal housekeeping, it is the difference between evidence and character attack. True crime storytelling often collapses that difference because scandal is easier to narrate than admissibility. Mark should not. The public record gives us enough to say this: the relationships after Dawn's death became part of the state's theory. Sandra Glass's account became a turning point, and the church context made the case feel like a betrayal, not only of a marriage, but of a community's moral expectations. Still, the center of this story is Dawn. Dawn appears in the court record mostly through the facts of her death. Not feeling well, Benadryl, a burned bedroom, forensic samples, a body that did not breathe smoke. That is a limitation of court documents. They are built to decide legal questions, not to recover a whole person. So the ethical task is not to invent a fuller Dawn. It is to refuse to let the case become only about Nicholas, only about affairs, only about doctrine, only about appellate procedure. The court record tells us Dawn was alive on Christmas night. It tells us she was found dead the next morning. It tells us a jury later found her husband murdered her. It tells us the fire did not kill her, according to the state's proof accepted at trial. It tells us the first explanation was wrong. That is enough human weight. The rest of the episode asks how a system moves from wrong explanation to murder conviction, and what it costs when the first answer is accident. Cold cases often turn on new technology. DNA, fingerprints, digital trails. This one turned, in part, on a person walking into the investigation with a story. That does not make the forensic evidence unimportant. It makes the relationship between evidence and narrative clearer. The body had signs that were uneasy from the beginning. No soot, no carbon monoxide, pulmonary edema, a pathologist suspicious enough to request toxicology, an investigator uncomfortable with the accidental conclusion. But unease did not become a murder case until the new facts in 2001 gave authorities a reason to reopen the lens. This is a recurring problem in death investigation. Investigators make early judgments under pressure. They need a working theory. They need to decide whether a scene is criminal, accidental, suicidal, natural, or undetermined. Once a case is placed in one category, later evidence can be interpreted inside that frame. In Dawn's case, the early frame was accident. A space heater can start a fire. Wrapping paper can burn. Benadryl can sedate. Propane canisters in a bedroom can look like careless Christmas clutter. Nothing about that story required a murderer. But if Dawn was already dead, everything in the room looked different. The heater was not merely a hazard. The wrapping paper was not merely clutter. The propane canisters were not merely a gift waiting to be put away. They became potential staging details in a room arranged to burn. The Washington Supreme Court's opinion does not ask us to solve the fire origin from scratch. It reports that the state's experts presented evidence that Dawn was suffocated before the fire began. The jury accepted the premeditated murder case. Later appellate courts refused to undo that conviction. What changed legally was not the basic murder finding. It was the meaning of arson as an aggravator. And here the case becomes unusually instructive. In many true crime stories, appeal means the defendant says the trial got everything wrong. This appeal was more surgical. Hacheney challenged numerous issues, but the Supreme Court focused on a precise statutory phrase, "in the course of." Did the murder happen in the course of arson? The court said no. The arson may have been close in time. It may have been part of the same night. It may have been connected to the concealment of the murder. But the death itself was not a probable consequence of the arson, because, under the state's own theory, death had already happened. That reasoning matters beyond one case. It prevents a cover-up crime from automatically transforming the crime it hides into something legally different. It forces prosecutors to match aggravators to causation, not just to narrative proximity. For listeners, that can feel frustrating. If the fire was part of the plan, why should the aggravator fail? The answer is that criminal statutes are not just moral labels. They are technical instruments. They decide punishment. They decide death eligibility or life without release. When the punishment is severe, courts scrutinize the words closely. In the Hacheney case, the words did not fit the sequence. That is not sympathy for Nicholas Hacheney. It is the law doing what it is supposed to do, separating proof of murder from proof of a specific aggravating factor. Years after the conviction, Hacheney filed a personal restraint petition. A personal restraint petition is a collateral attack. It is not the same as a direct appeal. The petitioner has to meet demanding standards. One of Hacheney's arguments focused on the toxicology report. The analyst, Egil Weiss, had died before trial. Other experts testified and relied in part on her report. Hacheney argued that later United States Supreme Court cases, Melendez-Diaz and Bullcoming, changed confrontation law around forensic reports and meant his conviction should be vacated. The Washington Court of Appeals took the issue seriously. It discussed the shifting law around whether forensic reports are testimonial and when the analyst must be available for cross-examination. It acknowledged that if the issue were being examined on a direct appeal in light of later law, the analysis might be different. But timing mattered. Hacheney's case was final. He was attacking it collaterally. The court held the newer rules could not be applied retroactively in the way he needed. It denied relief. This is not the kind of issue that usually drives a true crime episode because it is technical. But technical issues are often where the integrity of a conviction lives. A toxicology report is not just paper. It is a set of measurements made by a human system. Cross-examination lets the defense ask about method, context, chain of custody, assumptions, and mistakes. The United States Supreme Court's confrontation cases changed how courts think about that in certain settings. But a legal system also values finality. If every new procedural rule reopened every old conviction, the system would never settle. The question becomes, which new rules are so fundamental that they must reach backward? The Washington Court of Appeals said the rules Hacheney relied on did not cross that threshold for his collateral petition, so the conviction stayed in place. For Dawn's story, the confrontation litigation does not erase the factual arc. It sharpens it. It shows that the case did not end with a dramatic trial verdict. It kept moving through the machinery of law. Appeal, remand, resentencing, collateral review. And every time the case moved, the legal question changed. At first, was this an accident? Then, was it murder? Then, was the murder aggravated by arson? Then, were the trial procedures fair enough to survive later changes in confrontation law? Different questions, different answers. Same death at the center. The phrase, hidden fire, sounds like a metaphor, but in this case, it is almost literal. A fire burned in a bedroom. For years, it helped keep a murder theory from becoming the official story. Then, when the truth as alleged by the state came into view, the same fire became the hinge of a sentencing fight. The case asks listeners to hold two truths at once. First, the jury convicted Nicholas Hacheney of first-degree premeditated murder. That conviction survived. Public court records describe evidence that Dawn was suffocated before the fire began, and that a witness reported an alleged confession. The appellate courts did not overturn the murder conviction. Second, the Washington Supreme Court said the state could not use the arson aggravator in the way the jury had found it. If Dawn was already dead, then her death was not a probable consequence of the arson. The fire may have hidden the murder, but it did not legally cause the murder. Those two truths can feel emotionally mismatched. One is human, one is legal. One says a woman was killed, the other says a statutory aggravator was misapplied. But justice systems live in that mismatch. They have to punish crimes and also preserve the rules that make punishment legitimate. Dawn Hacheney's death was first read as an accident. The later court record says it was murder. Between those two readings were years, testimony, forensic interpretation, and a witness who changed the direction of the case. We should be careful with what we do not know. We do not have Dawn's voice here. We do not have real interviews. We do not have a full trial transcript in this production. We have appellate records, and those records are built for legal review. But those records are enough to tell a powerful story responsibly. A woman died after Christmas. A room burned. A pastor explained the scene as an accident. A body suggested there had been no breath in the fire. A woman later reported an affair and an alleged confession. A jury found murder. A high court corrected the sentence theory. And years later, the conviction still stood. This episode used synthetic source readings based on public court records. It did not use real interview audio or cloned voices. Sources include State v. Hacheney, decided by the Washington Supreme Court in 2007, and later Washington Court of Appeals personal restraint petition opinions from 2012. Full source notes are included in the production folder. For Dawn, the legal record cannot restore the life that was lost. It can only show the path by which one explanation gave way to another. The first story was a fire. The final story was what happened before it. One final source note, because this case turns on the difference between a story and a statute. In everyday language, people might say the murder and the fire were part of the same event. The courts did not deny that the events were close in time. The question was narrower. Did the murder happen in the course of arson, in the legal sense required for the aggravating factor? The Washington Supreme Court said no, because the death had already occurred before the fire. That distinction is why this case is useful for understanding true crime reporting. A responsible account has to separate motive evidence from proof from sentencing factors from appellate rulings, and appellate rulings from innocence. In this case, the conviction for first-degree premeditated murder remained. The aggravating factor did not. The later personal restraint opinions add another caution. Forensic reports may feel objective, but courts still ask how they were created and how they were challenged. Here, the toxicologist who performed the testing died before trial. Other witnesses testified about the report and relied on it. Hacheney later argued that newer confrontation decisions should change the result. The Washington Court of Appeals denied relief because those later procedural rules did not apply retroactively in the way he needed on collateral review. None of that makes Dawn a legal abstraction. It does the opposite. It reminds us that a person's death can move through many systems. Firefighters, pathologists, police, insurance investigators, prosecutors, jurors, appellate judges, and later collateral review. Each system sees a different part of the same loss. The ethical center remains simple. Dawn was more than evidence in a fire. The legal record gives us fragments, but those fragments show how a first explanation can become dangerously settled, and how a later disclosure can force the evidence to be read again.